Leading our discussion is John Malcolm. Mr. Malcolm serves as the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow. He is also director of our Edwin Meese Center for Legal and Judicial Studies. Prior to joining us here at Heritage, he held a variety of positions, including serving as Deputy Assistant Attorney General in the Criminal Division at the U.S. Department of Justice, and Executive Vice President in charge of anti-piracy operations at the Motion Picture Association of America, and the General Counsel at the U.S. Commission on International Religious Freedom. Please join me in welcoming John Malcolm. John.
Thank you, John, and welcome everybody to Heritage. So on January the 23rd, President Trump told a group of business leaders that he wanted to cut regulations by 75%, or maybe more, he said. That is an ambitious undertaking, leading many of us to ask, how could he do this? Well, one way he may be able to use is the Congressional Review Act, a law that was passed in 1996. Although somewhat obscure and rarely utilized, the Congressional Review Act could prove to be an extremely valuable tool, enabling Congress and President Trump to wipe away scads of regulations and agency guidance documents adopted during previous administrations that they don't like. We are fortunate to have with us today 3 experts to discuss the Congressional Review Act and its potential uses. We will first hear from one of the architects of the Congressional Review Act, David McIntosh, and after his remarks, I will introduce our other panelists. David is a graduate of Yale and the University of Chicago Law School, and he is currently the president of the Club for Growth, an advocacy group promoting economic freedom. Immediately prior to joining the Club for Growth, David was a partner in the Washington, D.C. office of Mayor Brown. He also served as a scholar at the Hudson Institute and has taught economics at Ball State Business School. While in law school, David co-founded the Federalist Society for Law and Public Policy, and currently serves on its board of directors. During the Reagan administration, he served as a special assistant to Attorney General Edwin Meese III and as a special assistant to President Reagan for domestic affairs. And during the first Bush administration, he served as executive director of the President's Council on Competitiveness and as an assistant to the vice president. But it was while he was serving in Congress from the state of Indiana, where he served for 3 terms, and in his capacity as chairman of the subcommittee on regulatory relief, that he introduced and helped secure the passage of the Congressional Review Act. David, the podium is yours.
Thank you, John. Thank you, John. It's great to be back at Heritage. I think the last time I was here was sometime a year ago when we were talking about the REINS Act. So the promotion of getting our hands around the regulatory onslaught is something that Heritage has a lot of track record with and deserves a lot of credit for keeping that out there at the forefront of the conservative agenda. I'm particularly pleased to be here with one of our panelists, Todd Gaziano, who worked with me when I was in Congress. I take credit for writing the bill, but it was actually Todd who wrote the bill and worked out a lot of the details and how it would work. He had the painful experience of negotiating with the Senate staffers on how to put it all together, and is today the leading expert on what the Congressional Review Act says and means, and has made tremendous headways with promoting, now that Congress is interested in it, getting them to focus on exactly how dynamic that can be. Let me step back and make a couple comments about regulation. John mentioned how such a burden it is, and the president's goal is to reduce them by 75%. Another laudable goal that he put out there was that for every new regulation, they would remove 2 regulations. Some people have questioned, how would that work? Is it feasible? I would let you know that from my time at the law firm, one of my partners in our London office came in about 4 or 5 years ago and said, do you know that the conservative government here has a new policy that before any of the departments can issue a new regulation, they have to remove a regulation. And I quizzed her on how that was working. She thought it was tremendously effective. And actually, in many cases, the government found it was a helpful tool in cleaning out the dead wood of regulatory systems that they no longer wanted. So I applaud the president for leading in that way. The magnitude of the problem's enormous. Back when we were working on the Congressional Review Act and the contract with America, the Small Business Administration estimated that the cost to the American economy of all federal regulations was about $775 billion. So less than $1 trillion, 750, 775. Today, their estimate is that it's over $2 trillion. So it's tripled in the intervening years on the impact that it has in the economy. Mercatus has estimated that the effect on GDP from, let me get the years right, 1980 through 2012 was to lower our total GDP by $4 trillion. So you can imagine how large our economy would be if we could add that back into the productive sectors. We all know the problems of regulations, the unnecessary cost, the burden particularly on small businesses who can't distribute the cost of that over a larger capital base. We've seen countless examples of this. The last one I read about was a company in Louisiana that had a construction firm. They'd go in and remodel older buildings. They were put out of business by an EPA requirement on how they would deal with lead paint. Now, lead paint's a real problem if you're going to have children living in the house, possibly eating it. But their controls were so obsessive and the training and the requirements they had to go through, they eventually said, we can't afford to do this business anymore, closed their doors, had to let all of their employees go. So that's the type of day in and day out consequence of these regulations that we see. So back to the Congressional Review Act. It was signed by President Bill Clinton in March 29, 1996 as part of the debt ceiling bill. It hadn't been one of the initial contract with America provisions, but when my class came in, we talked to Newt about doing something on regulatory relief. He put it in there and negotiated with the president to have it included in the debt ceiling. I do remember a New York Times article the next day where the reporter said the White House staff woke up and said, "What's this? How's that? We have to report to Congress now when we write regulations." But as you know, it languished for a period of time. There was the transition from Clinton to Bush where Congress overturned the ergonomics rule and used the Congressional Review Act for that. But since then, it has never been deployed. We're now back at a season where it makes sense for Congress to do that because you have a different president who will sign the bills. And it's a powerful tool. I'm delighted that Kevin McCarthy and Paul Ryan have taken the lead in the House to initiate these resolutions. I think the list is enormous. You look at something that Clyde Wayne Cruz put out at the Competitive Enterprise Institute. There's over 230 rules that were put into place by the Obama administration in roughly the last 6 months and would still be eligible to be overturned by Congress. Some of the key elements, and I'm going to let Todd really describe in more detail how some of these work, but one of them is that 60 session day look back in order for Congress to review it. Another one is that it only takes a 50 vote in the Senate. So you've got a streamlined provision, limited debate. Todd's looked at that and has some even greater ideas for the U.S. Senate on how they can compress the time and get more into their calendar. Already the House has passed 13. 3 of those have been passed by the Senate and signed by the President. 2 of them are saving billions of dollars already. One is an SEC compliance rule that dealt with natural gas companies and will save $1.3 billion that's estimated. Another was the Interior Department's stream protection rule. One of the problems, Senator Johnson called me up and said, "Where do they get these names?" You know, they've all got these names of goodness and light, but underneath them, they're doing these terrible things that don't really protect the environment, and they impose costs. And I said, well, you can always rename them in the resolution if you want. But this one cost another $1.3 billion, would have had the effect of putting out 25,000 or more coal miners out of work, because essentially it said we're going to create a buffer around any stream, and you can't do mining within that buffer. Now, I did notice the government's response was, don't worry about the job loss in the private sector. We've analyzed this, and we now know that when this rule goes through, there'll be a need for 250 engineers who are biologists and can go and examine these streams. So their answer to the coal miners was, all right, 25,000 of you, we know you're going to lose your jobs. There's welfare, by the way, if you don't get a better job. But don't worry, we're going to hire 250 engineers to come be on the government payroll and go watch these streams. It's one of the reasons I think the American people rejected the Washington message this cycle, is it's so self-serving and so unaware of the negative consequences it's had on average people in this country. The other 13, there's a lot of good rules in there. One of them that I noticed is a methane venting rule that will, when the Senate passes it and the President signs it, will relieve the natural gas industry of about $1.2 billion in costs. Let us be more competitive in the energy development. A second thing, and this was something that Todd really brought to the fore, is that the CRA can have a much broader impact because there's also a filing requirement that we built into it. We basically changed the definition of when a rule goes into effect. And for years, the agency, actually all the way back into the Bush administration as well, the agencies have not done a good job of actually following these requirements, which then gives the president the opportunity to say, nah, that rule never went into effect, we're not doing it. Gives Congress the opportunity to look even past or earlier than the 60 days and say you didn't meet the requirement. That clock will start when you actually do meet the requirement if the agency wants to finalize the rule. Tremendous, tremendous tool. I want to mention a couple of other things that we should think about in the regulatory context, because you all are writing about these things. You're focusing on what the government can do to remove 2-for-1 on the regulations. Hopefully some of you will go into the government and be part of the Trump administration. One thing is to remember that one of the ways the agencies have really moved the regulatory agenda is to use guidance. And guidance is basically a way that they get around the administrative procedure law requirement that they notify the public, take public comments, and go through a formal process to write and issue these rules. Actually, they call it an informal process. That's been more and more the way the agencies have operated because they want to avoid the accountability of that public notice and comment. Well, now that there's a new president, new administration, new agency heads, those guidance documents don't have to be repealed by another rule. Because the courts have said, you have a rule on the books, if you want to repeal it or change it, you got to go through the same process and put a new rule on the books. So it takes a new rule to repeal an old rule. But if it's a guidance document, the secretary can sign a document today and it's gone. And no longer costing the American public because of all of the impact that it would have. One of them that is actually despised in a bipartisan fashion is an OSHA requirement that is costing from the Ag Department, costing enormous amount of money on how they will store fertilizer. I don't know what the guidance is telling them to do, but it's an average of $25,000 to $50,000 more for each storage facility. If there's no benefits from that, the Secretary of Agriculture should just immediately get rid of that guidance document. The second thing to keep in mind as you're developing proposals for the Trump administration is a tool that I noticed the Obama folks put to use quite a bit. The regulatory process is complicated, it's boring, When I was working for Vice President Quayle, I put more audiences to sleep describing it than anything else. But there is a technique that the agencies have used that cuts short the time frame for writing a new rule. And it essentially is called an interim final rule. And it says, we've studied this, we've taken some comments for the proposal, and now rather than putting out our final rule and waiting 60 days for people to comment and then 2 years to address all the comments, we're going to make it go into effect immediately, and then we'll take the comments and we'll tweak it after that. So remember those terms, interim final rule. It's a powerful tool that the new administration can use. There are certain guidelines and requirements. The courts have said when and when you can't do it. But it's the expansive use of that by the Obama administration set a precedent that the Trump administration should use. And I guess one last thing before I leave, and that's to return to that subject of the REINS Act. Heritage has been a great thought leader on that. I do know that the proponents in the Senate want to bring it back. That's going to be the key place. I think we can easily get it passed through the House. It is, in essence, the final way to really make Congress accountable for these regulations, because before the major ones can go into effect, they have to receive an up and down vote and pass by Congress, and basically be enacted with a legislative vehicle. It flips the presumption from the Congressional Review Act, where under the Congressional Review Act, if Congress does nothing, the rule goes into effect. In the case of the REINS Act, if Congress does nothing, the rule dies and never goes into effect. It will empower the American people through their elected representatives to finally have a voice in these regulatory decisions that govern their lives. So keep pushing for that. It's going to be, use the CRA, administratively get rid of regulations, but make that procedural fix, because it restores the balance of Congress being responsible for legislative action when the agencies go beyond just simply making administrative determinations. Thank you all for coming. Thanks for having me.
So now let me introduce our other two panelists. So first, we're going to hear from Todd Graziano. Todd is a graduate of the University of West Virginia and the University of Chicago Law School, and he is currently the executive director of the Pacific Legal Foundation's D.C. Center, and he also serves there as a senior fellow in constitutional law. Immediately prior to joining PLF in 2014, Todd was an executive vice president and chief legal officer at a healthcare delivery company and a healthcare IT company. Following a clerkship with Judge Edith Jones on the Fifth Circuit Court of Appeals, Todd held a number of significant government positions, including serving at the Justice Department's Office of Legal Counsel, a chief subcommittee counsel in the U.S. House of Representatives, and as a commissioner on the U.S. Commission on Civil Rights. He also served for nearly 17 years as my predecessor here at Heritage, where he was the founding director of the Meese Center for Legal and Judicial Studies. After Todd, we will hear from my colleague, Paul Larkin. Paul is a senior legal research fellow in the Meese Center. He got his undergraduate degree from Washington and Lee, a master's degree from George Washington University, and his law degree from Stanford. He then clerked for Judge Robert Bork on the D.C. Circuit Court of Appeals. He has also held a number of interesting and distinguished jobs over the course of his career, including serving as counsel for the Senate Judiciary Committee, a federal agent with the Environmental Protection Agency, an attorney in the Department of Justice's Organized Crime and Racketeering Section, an assistant general counsel at Verizon, and as an assistant solicitor general, where he argued 27 cases before the United States Supreme Court. Todd, the floor is yours.
Thank you very much. And I'm going to speak from here because we're going to have the worldwide launch of a website here in 5 minutes, and I have to work the mouse. But I want to begin first by telling John I should have tried to stop you from going on about my background, but I do want to touch the two of them that you mentioned. First of all, how gracious I am to work for David. It was an extraordinary opportunity to work with you in that revolutionary Congress. We were told it was going to be revolutionary. Newt Gingrich was going to change everything. But we did accomplish some good with the Congressional Review Act. And unlike the judge I clerked for, where you never want to admit the cases that you, or the opinions you helped draft, David was always very gracious to his staff by promoting us, sending us out to speak. I think because he's nice, but also I think he knew that that would expand the effect that we would have, that his ideas would have.
And he would go on to do bigger and better and great things.
I have many, many stories, but I won't get into them today. But of course, about Heritage, returning to Heritage is my home. I left David to come here to work with Ed Meese, and I could get away with leaving David because David used to work with Ed Meese, and everyone loves Ed Meese. And as John said, we helped launch the Legal Center, and where I was happily for almost 17 years, and worked with these two colleagues before I left. And I'm happy to say that they have improved the Legal Center that now bears Ed Meese's name. So it's a special honor to come back and speak. And finally, it was a month ago exactly today to the hour that I was at a Heritage working group meeting that Paul was chairing, where I was explaining my new idea about how to use the Congressional Review Act to reach back even further than the traditional look-back period. And Kimberly Strassel of the Wall Street Journal wrote this column. She got wind of it secondhand. She interviewed a couple people, Paul and me. She called this idea a regulatory game changer. Well, I hope that it is, and I'm going to explain that to you today, but I'm also going to break some new news and talk about what Kimberly Strassel wrote about. I refer to, and on our new website, we refer to as CRA 2.0. But I'm going to explain an even more powerful idea called CRA 3.0 that I don't think has ever been discussed publicly before. And if 2.0 was a regulatory game changer, then hopefully you all will love that. Well, I'm going to pause for just a minute. To those of you in the audience can look to the side screens. This is the new website we are launching here at this moment. It's called redtaperollback.com. redtaperollback.com. And those of you who are texters, you can just text rollback to 51555. So those in the listening on the web and you can't see the screen, it's easiest to text rollback to 51555. If you scroll down the web page, you'll see here on the home page that there is information about the CRA as it was intended if Congress followed the law and sense rules. But I've also got further information, and I'll go through this a little bit more at the end, on these two new theories I'm going to present. So let me reach those two new theories. As David explained, the CRA requires agencies to send up every rule very broadly defined, even to include guidance, policy, expressly in the legislative history spells out why Congress wanted to pick that definition, because we didn't like the agencies circumventing notice and comment. So it would at least give Congress an opportunity to rule on major policy manuals and guidance documents. And of course, when those are sent up, as David explained, there's a 60 legislative day or session day period to use expedited procedures. No amendments of the resolutions are possible. Filibuster doesn't apply to kill those rules. And the one thing I'm going to stress on the traditional use of the Congressional Review Act is that the Senate has been wonderful to take up some of these resolutions of disapproval that the House has already passed, but there's a misconception that the Senate must allow 10 hours of debate on every rule. That's the maximum that the law allows. The Senate can choose to allow 10 hours, or it could do any amount or none. Since these are already rules that have been published, since they're non-amendable, the Senate doesn't usually allow 10 hours of debate on every single amendment to a bill. So the Senate, if it chooses, could do late night sessions. I've heard of a few senators who are willing to run late night sessions in order to kill more rules. But that's the traditional use of the CRA. And as David also mentioned, when the president signs a law, a resolution that kills one of these rules, the agencies are then forbidden from ever issuing a substantially similar rule ever again without subsequent congressional authorization. So I was very interested to listen to David's comment about how agencies, Trump administration can simply get rid of every bad guidance document with the stroke of a pen. That's true, and the agency should do so. But if it's afraid they'll ever come back again, what they should do is send it to Congress, because if Congress then kills it, no agency, no Warren administration, no whatever administration could ever issue that again. So now to the what Strassel wrote about. There are thousands of guidance documents and rules that, of all types that were never sent to Congress. On our website, you can find an explanation and some links to some government studies that show that, for example, there were 1,000 rules a year that were published in the Federal Register alone in recent years that weren't sent to Congress. Most of these are inconsequential. Many of them are not harmful. But my colleagues and I are finding dozens and dozens, and I bet you there are hundreds and hundreds, that are terribly abusive, illegal, some of the ones we're already litigating against, and we now know an additional reason why they're illegal. They're illegal because they never went into effect. They should never be enforced. The clock never started to run on the congressional review period. So if the administration ever, after an orderly review, the agency should be instructed to conduct an orderly review. But in the meantime, I want to work with others here at Heritage. I'm reaching out to my friends at CEI who I see here, and we want to compile a list. We will add that to the website of those rules that were never sent to Congress. If the administration ever sends them now, the clock starts ticking now. So there would be, let's say they were sent in 6 months or a year. There would be 60 legislative days after they are finally submitted to Congress for Congress to use the expedited procedures. But now let me tell you about 3.0. CRA 3.0 is simply that the Trump administration doesn't have to send them up at all. Remember, if they conduct this orderly review, they may find hundreds or thousands of rules that are thought to be in effect that have been wrongly enforced, where people may have gone to jail but shouldn't have, and they have the responsibility to determine whether to go final with them. Because under my reading of the law, it's as if these rules were stopped at the OMB review process, or they were required to be published in the Federal Register, as some rules are, but they were never published. And there's 3 reasons, but I won't go into all of them. I think I've talked to Paul, and I hope Paul writes another wonderful. Paul's written the definitive paper that he's going to talk about on why the CRA 2.0 theory makes sense and is consistent with the law. I hope he takes that same scholarly attention to the next step, which is that it's not a harmless error for these agencies not to follow. It can't be simply a technicality. One reason is the courts ever rule that the rules that were never sent to Congress are truly in effect, that violates 2 textual provisions of the Congressional Review Act, but it would also render it a nullity. And we know from King v. Burwell that the courts will strain mightily to interpret a statute to prevent it from being rendered a nullity. So the Obama administration could send hundreds of these rules up to Congress with a recommendation to let them go into effect. Previous administrations, when they send a rule, they always have that assumption, right? But this administration would be responsible for determining what to do with those thousands that were never sent up to Congress. It could then issue a notice in the Federal Register as to, let's say, dozens of them, hundreds of them, that they're just not going forward with them anymore. They're going to reconsider them. They're going to modify them. They're rethinking them. But in the interim, they'll send a notice that they are not in effect. And any enforcement action that's being brought against them should definitely be dropped. So that is CRA 3.0. So now back to the website. How can you all help? Well, on the homepage, if I can, I think I can get back there. Cullen is my colleague who built this website in about a week, did an amazing job, and he's holding his breath that I can demonstrate it. But you see right here on the homepage is a button, Find and Report Rules that were never submitted to Congress. We found dozens. My friends have, actually, it's about a list of 98, but we're working on describing them all. So if you click that button, you'll come to this section of the site. And this section of the site explains the broad definition of a rule and asks you to go to the GAO database of all rules that were ever submitted. And if you type in the agency and the title of the rule, and you don't come back with a hit, it probably means it was never sent to Congress. And if it was never sent to Congress, what we want you to do then is to fill out this response form and send the name of that rule to us with a description of why you think it's a bad rule and why you think we should add it to our list that it be killed. Eventually, we're going to augment this site. Eventually, we're going to try to create a searchable database of what I suspect would be hundreds of rules if Clyde Wade Cruz can help us and others at Heritage, our friends James Catuso and Darren Baxt and others can help us, a searchable database of rules, and we'll have a dirty dozen maybe at the top of our website to help the administration understand that they need to implement the CRA effectively. Congress can work with the administration, implement it effectively. And the last thing I will say is, very excited about this website. You all saw it first here, but we're also going to invite partners to join the website. I think I have a tentative agreement from the Club to Growth to be a partner on the website. I'm extending.
I'll accept your invitation.
Oh, great. I'm extending a similar invitation to CEI and Heritage and a few others, and I think in the first 2 weeks they will be founding or original partners. It's like legislation, you know, there's sponsors and there's original sponsors. Co-sponsors and original co-sponsors. So we want, for the next 2 weeks, to try to add some original partners to this website. I will point out here in the, we have a blog, but we also have a doubly enter in the scholarly reports. We have several people in the audience, including Paul Larkin, Clyde Wayne Cruz, Darren Baxt, and James Gattuso's. But we have more and more reports, and maybe these partners will help us populate the website. So with that, I am thrilled to help create mischief if that mischief leads to the elimination of terrible, abusive, and illegal rules. Thank you.
We all learned in the first grade the value of having an eraser on a pencil. In 1996, Congress learned it too. It passed the Congressional Review Act of that year as an effort to try to trim the excesses off the administrative state, but to do so in a constitutional manner. Historically, what Congress had done was sprinkle legislative vetoes throughout the U.S. Code on a variety of different provisions that allowed both houses, and sometimes either house, to veto an agency rule simply by a majority vote. The Congress thought this was a reasonable way of going about legislating, since, after all, it didn't have to create the agency in the first place. It didn't have to empower the agency to adopt rules. It didn't have to empower the agency to adopt this type of rule rather than other types. And so Congress believed that since the greater includes the lesser, the ability to control what agencies did in gross also allowed them to control what agencies did in part. The presidents disagreed, however, and ultimately the presidents wound up winning that dispute in the Supreme Court. In a case called INS versus Chadha, the Supreme Court held that the legislative veto violates the bicameralism and presentment clauses of the Constitution. That was a 1983 decision, meaning that no longer could Congress use the legislative veto as a means of addressing this problem. The following year, the Supreme Court decided another case, NRDC Chevron versus NRDC. Chevron took what was a problem and made it acute. Why? In Chevron, the Supreme Court jettisoned the old-fashioned rule adopted in Marbury versus Madison that the courts have the responsibility for saying what the law is. In Chevron, the Supreme Court put a wrinkle in that. They said, that's true if a statute is clear. But if a statute's ambiguous and it's entrusted to an agency to administer, then what the agency says the law means governs. Even if a court would have decided the matter differently, were the court the first one to resolve this issue. So now you're in a position where Congress could not review the rules that agencies came out with under the legislative veto device, but the year following that, these rules and agencies' interpretations were given a boost of authority in the case called Chevron. Now, legislation takes a while, but ultimately it gets done sometimes, and in this case, it took a little bit more than a decade, but the Congressional Review Act was Congress's response to this sort of problem. Let me talk in particular about two aspects of the act that I think are the most pertinent to the discussion we've had today. But the important point to remember is it gives Congress a chance to review agency rules and, if it finds them wrong-headed, to pass a joint resolution that, if signed into law by the President, nullifies that rule and, as my colleague Mr. Gaziano said, not only that rule, but anything substantially similar. Now, what can it nullify? The critical term in this regard is reports. And a report is broader than a regulation. Now, I know sometimes reports are referred to as interpretive regulations, and the old-fashioned regulations are referred to as legislative regulations. But if you look at it this way, I think it may help. The regulations that govern primary conduct are essentially junior varsity statutes. What they do is tell the public what it must do and what it may not do. But you also have things in addition to the junior varsity statutes called guidance documents, opinion letters, and the like. They don't in themselves tell you what you must or must not do. Instead, they say what the agency thinks the statute means, and therefore what the statute says you must do or must not do. Now remember what I said a few minutes ago. If the statute is at all ambiguous, and whether or not a statute is ambiguous is often a debatable question, but if it is ambiguous, then what the agency says the statute means governs. So we now are in the position where agencies can issue rules in the form of the regulations, the junior varsity statutes, and rules in the form of interpretations that effectively govern private parties. So the CRA decided, rather than use just the junior varsity statutes, because we knew from the Chevron case that their interpretations of the Congress's statutes matter, the CRA uses the term rules, and that includes interpretations. So if agencies don't go through the notice and comment process set forth in the APA necessary to adopt a regulation, but just instead adopt it in a guidance manual, adopt it in the form of a Dear Colleague letter, that's a rule. And that's something that Congress can review under the Congressional Review Act. Now, when does this whole process start? It starts at the later of two events, either when the agency publishes its rule in the Federal Register, which is standard practice for any rule that the agency wants to adopt, certainly in the form of a regulation, or the day it is submitted to Congress. So if the agency adopts a rule and publishes it in the Federal Register and doesn't submit it to Congress, the time period for the Congressional Review Act has not yet begun to run. It hasn't been triggered. You can't schedule a vote on a rule that hasn't yet been submitted to Congress. Plus, when it's submitted to Congress, it also has to be submitted to the Comptroller General so he can do a report for Congress on the rule. So we're not talking simply about, a fastidious detail examination. We're talking about a matter that has a substantial effect. Why? The very first words in the Congressional Review Act are, before a rule can take effect. So if a rule is adopted by an agency and it's not been published in the Federal Register or sent to Congress, it's not in effect. If it has been published in the Federal Register but not sent to Congress, it is not yet in effect. So what does that mean in terms of the reach back of this? Well, it's a 1996 statute, and under settled Supreme Court case law, statutes generally apply only prospectively. So anything that happened before 1996 is really not fair game. But for rules that were never submitted to Congress, the Congress can, if they are resubmitted, reach back as far as 1996. So if the agency adopted a rule in 97, 98, et cetera, it can come up now. Now, we know this, the Congressional Review Service has said that, Congressional Research Service has said that the period in the statute goes back at least the 60 legislative days to around, I think it's June 13 or something thereabouts is the date. In fact, if you read the statute strictly, it goes back further because unless a rule has been submitted to Congress, the time period never started to run. So there is the potential there for a significant opportunity to eliminate regulations that Congress and the President deem inadvisable. Now, what's going to happen going forward? Well, as my colleagues have said, people will start examining rules. They will start trying to see if a rule was published in the Federal Register, and if it was, whether it was also submitted to Congress. Because if you didn't satisfy both of those, you didn't jump through each hoop, the time period is still available for it to be submitted to Congress, and if Congress wants, it can then invalidate it. People are also going to start preparing a list of priorities. A rule that has an adverse $5 billion effect on the economy is going to be more important than a rule that has an adverse $5 million effect on the economy. And what you'll see then is not simply a list of, say, the top 100 rules people would like to see gotten rid of, but people will start preparing priorities amongst them. Here are the 10 worst rules for the American economy, because if you do a cost-benefit analysis, you will find that the costs greatly outweigh the benefits. Oh, and yes, the benefits have to be calculated the right way, too. It is oftentimes the case that agencies, when they're calculating benefits, look at the benefits that occur overseas, even if all the costs occur in the United States. That's a mistaken way of looking at this. Generally speaking, statutes are presumed not to apply overseas. And if the statute presumptively does not apply overseas, then you shouldn't be calculating the potential benefits from a statute that would occur in a land where the statute doesn't apply. With the result being that if you do a proper cost-benefit analysis, you may find that there are a variety of rules that should be invalidated by Congress that you might not previously have thought so under the cost-benefit analysis that maybe the agency already had performed. Now, ideally, what you would see is the Director of OMB order each of the federal agencies to submit a list of all the rules that have been published in the Federal Register as well as submitted to Congress, and then do a comparison between column A and column B, and anything that is not on both is in column C, and that now is eligible to be submitted to Congress and for Congress to invalidate it. And as my colleague said, it gets considered and potentially invalidated under a very fast-track procedure. Now, does that mean you want 500 rules going up all on the same day? No. You want them spread out. You want them spread out so that they can all be considered. Anything you send up later that had not previously been submitted, even after you found out it hadn't been submitted, can in fact still be considered. So if you send them up according to the priorities that they have, and the priorities ultimately has to be worked out, I assume, between the President and the Congress. If you send them up in that manner, you can go through and on a step-by-step basis eliminate needless burdens on the American economy. The President and Congress have said they're very interested in doing that because it will help put people to work. There is a way they can do that. They can do that under this statute. They can do that if they do some digging and find out rules that hurt the economy and have not yet been submitted to Congress. And they can do that if they prepare a list of priorities and carry through on that list by sending them to Congress on a periodic basis. so that Congress, if it agrees with the president, can invalidate these rules. Following that approach will help eliminate rules that keep people from being employed, whether they couldn't get a job in the past or they can't get one now. Either way, there is the potential here, for the first time actually in the life of this statute, for it to serve one of its intended purposes, which is eliminate needless dampening of the economy. And I say first time during the life of the statute because, keep in mind, the president's own Office of Management and Budget reviews every rule. So it's unlikely that President Clinton would have signed a joint disapproval resolution eliminating a rule that his Office of Management and Budget had approved. Back in 2000, you had a Republican president, a Republican House, but the Senate was split 50-50. And in fact, it wasn't long after that that Senator Jeffords switched out of the Republican Party, meaning now you're not likely to be able to get it through the Congress. In 2009, when President Obama took office, he had a Democratic majority in each house, and he could have gone back through and eliminated regulations if he wanted. But President Bush didn't spend the time that President Reagan did trying to go through and eliminate needless regulations, so there may not have been very many that he wanted to eliminate. Or if he did, he could have done it just through, as it has been said recently, the pen and the phone, just eliminating rules that are not actual little statutes by just telling the agency to repeal it or eliminate your guidance document, whatever. Bottom line is this: the statute was passed and became law in 1996. But it is only now that we have the opportunity truly to see it work. But it is now that Congress and the President have that opportunity. And I hope they take advantage of it, because it will help boost an economy that is still not yet completely moved up from the Great Recession. Thank you.
Well, I'll stand so I can see over here. In a moment, I'll open it up and take your questions. Let me begin with one, which is, Todd, you talked about how the president could say, well, I don't think these rules were ever in effect because they were never submitted to Congress, and therefore I'm going to stop all enforcement actions, just sort of say we're revisiting the issue. I'm assuming that one of the things that a combination you could do is you could say, we're rethinking this. We're going to suspend any enforcement actions, but on the sort of timetable that Paul suggested, then tell the agencies on a date certain, whatever that date is, you shall submit these to Congress. So then they can be subjected to CRA review. And of course, if it ends up going through and the president signs it, then in a future Democratic administration, you cannot renew that regulation, right? So
I agree with 90% of it.
Okay.
With one caveat. Absolutely, they should just suspend enforcement because it's lawfully not in effect. So that's the initial step they have to take. They don't then have to, you're right, that they should take some time to decide whether they want to modify, change, whatever. And here's one thing I meant to say in my opening remarks. If it was a notice and comment rule that David said normally requires notice and comment rulemaking to repeal, that's only when the rule has actually gone final. Do you need to use, we're in uncharted territory, but in my view, if it went through notice and comment rulemaking procedure, let's say 6 years ago, it's been wrongly enforced, this president has the determination as to whether to go forward. And the one exception to the scenario that, there should be some time period from when you announce it's not being enforced to whether to send it to Congress or not. But if it's one that they don't want to bother Congress with, they simply, I think, have the responsibility and the power to simply not send it to Congress and say, we're ending this rulemaking process. This was a inappropriate, wrongful, whatever. We may start it over again, but we're not going. So as I said, so they may send, after this long review period, they may send hundreds or thousands to Congress with their recommendation that normally attributes to every rule. We think these should go into effect. They could then send dozens or hundreds on this very orderly basis that Paul and you talked about to get Congress's buy-in. either we're not sure, we want political cover, we think Congress should take responsibility, but also to make sure that if it's so bad that it's never allowed to be issued again. And then for some other group, they don't need to bother Congress. It's this administration's responsibility whether to finish the rulemaking process. And this administration could simply say, we thought about it and we're not going final. That's what happens if it's a normal rulemaking process, an OMB review finds some rule. There are some rulemakings that just never go final.
All right, with that, let me open it up to questions. When you're handed a microphone, I would ask, please identify yourself for purposes of an affiliation. And please, this is not a time for you to make a speech. Just get to a question. Let's start right here.
Hi, I'm Peter Ferrara, Heartland Institute and the National Tax Limitation Foundation. I wanted to ask, to what extent has the leadership of the House and the Senate, the current leadership, indicated a willingness to utilize Congressional Review Act 2.0 and 3.0? Apparently, they've already recognized the 60-day period, and they're apparently already working on that 60-day period. But to what extent are they thinking, well, when we're done with these, we're going to go on and do 2.0 and 3.0?
I haven't addressed that with them, so I don't know what they've thought about it. My guess would be they're focused on the immediate and haven't thought about it one way or the other, but I don't really know that, Peter.
Okay.
All I can say is that, yes, they're focused on the immediate, but I've gotten contacted by a lot of members of Congress who are enthusiastic in following up, but nothing official. That I think the first step really needs to be, I shouldn't say needs to be, the first step in some sense has to be from the administration, because the administration has to decide to send up these old rules or not.
So a couple leaders that I've found are really enthusiastic about this. One, Kevin McCarthy, who is really leading the effort to get the House to do this. It's important that it be at that level because the committees have a difficult time using the CRA Act. It's one of the reasons it's never really been deployed well. And in the Senate, Johnson, who has the equivalent of the Government Oversight Committee, he was telling me we should be in here 24/7. And I think he persuaded Mitch McConnell to use floor time for these. So he deserves a lot of credit for that, and they're moving forward now. Tillis, a new member on the whip team, has been the one sort of charged with rounding up the votes, because in the House they can vote and assume they're going to get the majority and pass it. In the Senate, with just a 2-vote margin, they've got to be careful and count them all. So I appreciate what they're doing. Reinforcing them, talking to them about these ideas would be the way to do it.
So if I have the opportunity to raise the issue before Paul Ryan and or his staff, or to the director of OMB and or his staff, that would be a useful service.
Very much
Yes.
so.
I think it's safe to say that up before this meeting that took place a month ago that Todd was talking about, that people just assumed that the clawback period was 60 days. They hadn't given this much thought. And one of the reasons why we had that meeting in Paul's paper and now we're doing this program is to say, well, actually, we think it's a lot broader than that, sort of to spur a discussion. We had a question down here.
Thank you. Tom Curry, I'm a reporter with CQ Roll Call. One question I had is, I assume the answer to this is no, but I just want to make sure. Has any court ever held that these guidance documents, opinion letters, et cetera, that Mr. Larkin referred to, are rules within the meaning of the statute? Another question is, why did the Obama administration, these rules that were published in the Federal Register but never submitted to Congress as required by the Congressional Review Act, why did the Obama administration officials do that? Was it just carelessness? Was it a deliberate decision not to subject them to the CRA? And if some industries and companies think these guidance documents, opinion letters, are still good law, some companies within industry think they're still good law, other companies think, no, they're not in effect. It seems like it would create a lot of confusion about what the state of the law is, at least in the short term.
Paul can possibly talk about the court decisions. I don't think a court has ruled that guidance documents are or not, and the reason is because there's a couple of reasons why I don't think the courts would have yet. And that's because Congress hasn't disapproved, has only started to disapprove. There was only the ergonomics rule killed before this year. And so that didn't lead to challenges. But I think Paul's paper's very, very convincing, and there's not a lot of dispute. He can comment on the definition of a rule that was selected in the act does cover it. But legislative history, if you want to read the law, go to our website, click here, and you can see both the law and the legislative history. The legislative law and legislative history are at these links, and it's very clear from the definition chosen in the legislative history why Congress chose the definitions to incorporate guidance documents. As to the second, why were so many not sent up? Well, I can tell you two things. I think mostly it was inadvertence. In some agencies, I suspect, with a very high non-compliance rate, and there have been people studies, I think there was a little hostility to sending up their wonderful works to Congress, to think that members of Congress could take it. But in the most case, I think it was inadvertence. But the Obama administration's OMB sent 2 circulars to the agencies urging them to comply after GAO started pointing out to Obama OMB, and I can try to find those. I know you've done some great reporting on this. I can try to find those circulars. But that is proof of 2 things. That's proof that the Obama administration was concerned and knew that the agencies weren't complying. And secondly, urging the agencies to send up these old rules is sort of a further admission that the clock doesn't start to run and they're not in effect until they're sent up to Congress. Why would Obama OMB send that circular to the agencies if it didn't think there was some peril to those guidance documents and those rules? So I think it's a pretty open and shut case.
Yeah, let me just add that it may simply be a matter of there's only so many things the White House can control at any one time. And as the result, they relied on the agencies to comply with the statute. And there's only so many things that the secretary for each agency can do. And since this had only been invoked one time, the secretary might have thought this wasn't an important matter because it doesn't affect what we're doing on a daily basis.
I saw a hand up over here. I did get a question here, although I know that the House and Senate has their own sort of repeal and replace strategy for Obamacare. I'm assuming that regulations promulgated under the Affordable Care Act, the same kind of thing that we're talking about here, could apply.
We found a few that weren't submitted.
Yeah. Let's go over here.
Very good.
Thank you so much. Good afternoon. I'm not sure who to direct my question to because you've all proven you're exceptional experts on this. Maybe Mr. Gaziano. I really appreciate your presentation. I think the CRA is an invaluable tool. But I was wondering if you could speak to any unintended consequences or the potential for misuse or improper application. For instance, the CRA was just used for Dodd-Frank, the anti-corruption rule, as I'm sure we have differing opinions on. But the fact remains that that rule was debated in Congress as well as in the Senate. As well as by the SEC. It had actually over a 10-year legislative and regulatory history. So I was just wondering if you think that this kind of rule, I mean, it wasn't a midnight rule, and I would argue, but do you think that represents a misuse of the CRA or it might be an overreach of the CRA? That was my question.
I think that's a great question. I hope my fellow panelists will answer too. But I've heard a similar complaint, which is that this was an obscure law and it's unfair. I'm not characterizing you, but some other people, which sounds it's unfair to use an obscure law to kill a regulation. And I heard there was one bureaucrat in a different agency said he worked for 7 years on the rule. He was paid for 7 years, and when it was delivered to Congress, a majority in both houses of Congress passed what's called a law. That's what the resolution of disapproval is. Our Democratic representatives, the CRA, as it was originally passed, and I'm going to give more credit to David, he foresaw the REINS Act. We defined the major rule in it so that intentionally the REINS Act could eventually be passed. If we didn't define the major rule, there couldn't be that distinction. But the Congressional Review Act, as it is just a minor return to democratic accountability that the constitutional separation of powers requires. And I think it's very almost telling of the bureaucrat who was upset because he's arguing for a right that the rule he worked on for 7 years and got paid for needs to go in effect because he worked on it so hard. The idea that Congress can't use expedited procedures to, without the filibuster, to take an up or down vote and overturn that rule says more about, I don't know, how the administrative state has flipped constitutional separation of powers than anything else.
Yeah, let me add just 2 points. First, what you're essentially saying is that after a certain period of time, a rule should be deemed valid even if it was never submitted. That's tantamount to saying there should be a statute of limitations in the Act, and there isn't one. Secondly, the problem with remedying what you're talking about is worse, perhaps, than the problem itself, because trying to decide how long is too long would require a court or whoever to engage in an undirected line-drawing exercise without anything in the text of the statute to offer any answer as to what is and is not an appropriate period, what are and are not important factors to decide in how long that period should be, whether there are exceptions, necessary and sufficient conditions, and the like. People make mistakes. There is, unfortunately, times when people rely on the mistakes made by others. Perhaps that should be worked out in the enforcement process, where the government, if someone relied on something to their detriment, the government should not now go after them and try to enforce a law against them. In fact, they probably have a pretty good argument, I would think. But you can't just reach back and say, okay, we can only go back to 2003 or 2 or 4. Without pointing to something in the statute that says where you stop. And there's nothing in the statute that says where you have to stop.
And let me just add, for the rule, the Dodd-Frank rule that you talked about, it was maybe a 10-year, I'm not sure how long, I don't think it was quite 10 years because it was only past 8 or 9 years. Okay, but in any event, the rule that was just disallowed wasn't one that was issued years and years ago. That was one that was actually issued in the last 6 months. So it is a recent rule, and when it was submitted, it wasn't even in effect. It had to be upheld for, I think, 60 days. And the idea that Congress shouldn't use, there are civil rights laws we now are really important in civil rights protection that were passed after the Civil War, and they were abandoned for 80 to 100 years, but now they're the centerpiece of civil rights enforcement. That's what the Congressional Review Act is for returning. The title of today's program is wonderful. It's a reawakening of the Congressional Review Act, this tool that the agency should not have been ignoring for 21 years, and which now I hope will influence agency behavior to write better rules if they know Congress might actually be looking at it.
Over there.
Yeah, hello. My name's Neil McCabe. I'm with Breitbart. The two questions, one real quick, and I think one I would hope would be a little bit more lengthy answer, is on executive orders. Are executive orders in the same universe as rules and regulations? And if you could just
No.
okay, very good.
Paul,
The Congressional Review Act takes the definition of reports from the Administrative Procedure Act, and the Administrative Procedure Act does not apply to the President.
And could you describe any kind of interaction or partnership you've done with the Trump transition team, the landing teams, and also House Freedom Caucus, which was also producing a list of regulations that could be gotten rid of?
I personally,
Well,
I'm sorry.
it's on behalf of Heritage. We're a 501c3. We've put out position papers. We'll provide education to people who ask about it, but, you know, we're not actively working.
None of the panelists interacting?
Well,
So-
I'm just speaking on behalf of Heritage.
Yeah, so
No, I-
the club, we've talked to the Freedom Caucus people and urged them to do this. We've also encouraged Senate leadership and House leadership in that.
Yeah, I wasn't involved in the transition at all, but I am aware that the House Freedom Caucus put out a report in December of 2016 where they identified a variety of rules and regulations that they hoped would be reconsidered.
Our work
So
has
you might
certainly
want
been
to look at that.
disseminated to them.
I am publishing this to the world, this website. The administration, please call me. Please call me. I think I've talked to some of them. Some of them have been my longtime friends. I don't know where they may be in the Trump administration, but now is the time I'm calling on them to talk to me. Please do.
We've got time for just a couple more questions. Let's come down here to Robert, and then I'll take one question from the three of you, and my apologies to the other two.
Robert Ault from the Buckeye Institute. You've talked about the role potentially that Congress and the President can have with regard to the CRA. I was wondering what, if any, role the court might play with regard to this. I know there's some limitations in the statute with regard to judicial review, but if, for instance, an agency failed to issue the report to Congress under this, which is a prerequisite for the regulation taking effect, and an individual or corporation were adversely affected by the regulation, would they be able to bring an action claiming, for instance, that any enforcement is ultra vires because the regulation is not in effect under the CRA?
And that was the type of case that I thought you were asking about. I'm unaware of those progressing, in large part, I suspect, because the attorneys for the private sector petitioners hadn't focused on the Congressional Review Act and the change in the process there. I would predict there will be some test cases coming up as more attention is now being paid to this, and it clearly is a procedural flaw that the agencies either have to correct or I think it's not settled law, but I think, Todd, in my view, is the rule has not become final and therefore can't be used to prosecute or otherwise it'd be outside of due process to require people to pay civil fines and others based on a rule that never followed the final steps in the process to become final a rule of law.
Yeah,
I don't think that's been settled yet in the courts, but that'd be, I think, a very respectable position for an attorney to take.
the Congressional Review Act says, if I am paraphrasing, is no determination, finding, action, or inaction shall be subject to review. So it's quite clear that Congress wanted certain things not to be reviewed by the courts. What's unclear is whose determination, finding, action, or inaction. I think it's fair to say that Congress did not want its actions subject to judicial review. It did not want the president's actions subject to judicial review. But it would have allowed perhaps some judicial review of what agencies had done. And there's at least one context in which this could come up where there would be, I think, an opportunity for judicial review. If an agency brought an enforcement action against someone for not complying with a rule that had not yet gone into effect, the party against whom the government sought to enforce the rule could raise a defense under the CRA that the law was not yet in effect, and therefore raise a due process claim. Because the phrase is actually due process of law. And although most discussions of due process turn on the procedures involved or the substantive rules, it's a mistake to forget that it's due process of law. There has to be a law that allows the government to take your life, liberty, or property. And if there isn't, it's no different than what King John was doing that led to Magna Carta. So what you have is a circumstance where someone should be able, I believe, to raise a due process claim that there is no law that authorizes the government to take this particular action to deprive me of life, liberty, or property. And to my knowledge, no court has said that Congress has precluded constitutional claims from being raised in that manner under the CRA.
Let me just add a very brief note. I work at the Pacific Legal Foundation, and our business is to sue the government. And so we're looking for opportunities if the government does not wipe these rules off the books. But I'm hoping, remember, I'm calling for the thousands of people in the Trump administration to call me and do the right thing. But if they don't, we will sue. And back to our website. Redtaperollback.com took me 3 clicks to get to this portion of the legislative history, which explains the limitation on judicial review that the original co-sponsors in both houses, David's speeches are the only, well, I should say the most important ones that were said on the House floor, but otherwise this is the official legislative history, and it explains exactly what Paul said, that the courts can't reach OMB determinations because that's a White House determination, can't reach certain other things, but they certainly have to give effect to whether a rule is in effect, and they, I think, will also have to give effect to resolutions of disapproval that are passed as to what is a substantially similar rule. Those are the two things that I think courts probably can take into account.
So I knew this discussion would generate tons of questions, and my apologies. We do have time limitations. I did promise one more question over here. Did you still want to ask your question? Let's go right here. Yeah.
Hi, my name is Ariana Skybell. I'm a reporter with E&E News. And I'm wondering how the rollbacks of these rules that you're proposing will impact rules that are statutorily mandated. And I'm also curious about businesses that have already sunk a lot of money into compliance, and if you are worried about that disadvantaging them in a competitive environment.
Let me take a stab on that. The first question, if the statute is mandatory that the agency issue the rule, they have failed to or has been disapproved, they still have that obligation to issue a rule. What, as Todd pointed out, what they can't do is issue one that's substantially the same rule over again. So they'll have to go back to the drawing board. So there's always an argument as you're trying to figure out good policy in these regulatory review processes of where is it most effective to relieve the economy of unnecessary costs. And as you pointed out, if somebody has sunk in a lot of capital costs to comply with the regulation, then there's not as much savings because they've already spent it. They would come in and argue it's also unfair because now a competitor in the absence of this regulation wouldn't have to spend the same cost. I think that those are policy questions the Trump administration needs to take into effect. When we were doing it at the Competitiveness Council, if we'd set our priorities on new and future rules, because you'd avoid the capital costs. But if you were confronted with that, okay, Congress has disapproved this, a lot of people in the marketplace have spent money complying with it. My answer is go back, and this is an answer to a question I got last night in New York, a very thoughtful question. Okay, you want to get rid of regulations, how do you protect, and in their word it was fairness, because they were thinking of financial regulations, but how do you protect the social values of a fair playing field, safety, health, the environment? And the core answer for those of us who are skeptical about regulations is you rely on market forces and you have a regulatory regime that gives you robust competition and transparency. So in the answer to this question, yes, some people have sunk in the capital, but return to the market forces, and if it gives them a better product, they'll go and compete. If it's actually not a better product for the consumer and there isn't a social good with it, then their competitors will come in and not have to spend the same amount of money. The great example of when you choose to rely on market and when you do regulation, I think, is FDA, where we want to have FDA scrutinizing the make sure that drugs that come on are safe, they're not going to kill somebody. But then the third stage that they use looks at it and says, well, there's already a drug on the market that sort of does this. Is it going to make enough difference that we'll let a new one come on? My answer there is government get out of the way, let the marketplace sort that out, and let a competitor come in and bring that new drug if it's shown to be safe. So that gives you a real-world kind of example of when you'd rely on markets versus when you'd rely on government intervention. And to answer your question, I think the sunk capital, almost the answer is, okay, yeah, the policy's changed. Use that sunk capital now in the marketplace to show you've got a better product, but your competitors don't have, we're not going to force them to sink in capital on something we don't think is worthwhile.
Just two quick responses, consistent with what my colleague said. First, from the consumer perspective, you have to say that may be true, but it's unfortunate. You don't want to hamper other companies from competing with the one that has sunk costs, because then consumers lose out. Right. Secondly, if you look at this on a going forward basis, letting America know that this law has to be complied with, and therefore this rule has to be submitted to Congress, will avoid those problems on a going forward basis. Or Congress, if it doesn't like the rule, will get rid of it and nobody has to sink the cost at all.
Well, I think it's safe to say that this is not the last that we have heard of this issue. Please join me in thanking our panelists.
Thank you.